If everybody is settled down from the excitement of Senator Klobuchar's terrific speech, I think we'll get started with our panel, the Weaponized First Amendment, just to make sure you're in the right breakout session. I'm Linda Greenhouse from Yale Law School, and I will briefly, well, before I introduce our panelists, I have to give you the logistics, which is to turn off your cell phones, and we must begin and end on time. Okay, so we're supposed to go to 3:45, and around 3:20 or so, we'll open the floor to Q&A, and people are asked to use that standing mic and identify themselves. If audience members would like to tweet about the session or their national convention experience, ACS's Twitter handle is @ACS Law, and the hashtag is ACS16, and there is CLE credit available. You can get more information at the CLE table outside. Okay, so by our very title, the Weaponized First Amendment, that is not a casually chosen title. Can people hear me okay? Yeah. And it obviously, suggests that there's something to talk about, that something's happening with the First Amendment. Maybe some people think that's a good thing, maybe some people think that's not such a good thing, but in any event, I think it's fair to say that the First Amendment has morphed into something other than the First Amendment that at least those of us of a certain age grew up reflexively saluting whenever it showed its face. So to discuss this very rich and quickly evolving constitutional topic, we have, ACS has assembled for us a great panel of experts, and I'll just very briefly introduce them, and their full biographies are in your program. So directly to my left is Professor Martin Reddish from the Northwestern University, Pritzker, right? All these people who donated lots of money to law schools, all the names are changing. Yeah. Northwestern School of Law, who's a noted scholar of the First Amendment. Next to him is Dan Tokaji from the Ohio State, Moritz College of Law.
20 million.
Who is
we got 100 minutes.
Well-known.
Not to date you.
Dan is a former national board member of ACS and a well-known scholar of election law and particularly voting rights, which, as you know, is a priority of ACS these days. To his left is Tamara Piety of the University of Oklahoma College of Law.
University of Tulsa.
Also a noted scholar of the First Amendment, whose recent book, Brandishing the First Amendment, may suggest by its title where she comes down on some of these issues. And to her left is Paul Smith, former board chairman of the ACS, current board member, who, unlike the other three, is actually a Supreme Court litigator of great note, and he's argued some very important First Amendment cases, and is deeply involved in the weeds of actual First Amendment law where it lives these days. So going back to my initial framing, that something's up with the First Amendment. And what is it exactly that we should make of it, Tamara, and what's happening and what should we think about it?
Okay, make sure that this is on. It doesn't seem like, can you all hear me? Okay. I think everybody is, the first part that something's happening is relatively uncontroversial. No matter whether you think it's a good thing or a bad thing, it's pretty obvious that something is happening. Just to give you a quick overview of the range of kinds of topics that have had the First Amendment raised, we have a case striking down a requirement, I think it was a reg relating to fair labor practices, the National Association of Manufacturers versus NLRB, posting what the law is, striking down parts of laws regulating security on conflict minerals, disclosures in the securities law, occupational licensing, so the Edwards case, and here in the District of Columbia about licensing tour guides, an unsuccessful attempt to attack a law that was regulating the licensing for dealers in precious metals in the Sixth Circuit, Liberty Coin, graphic cigarette label warnings, GMO labeling, green labeling, all sorts of things that relate to nutritional labeling and other kinds of labeling. The attempt in California to regulate crisis pregnancy centers, so these centers that advertise that they are dealing with crisis pregnancies and then try to talk women out of getting abortions. The San Francisco has tried to attack that as false advertising. And, on and on and on. Of course, everyone knows about Citizens United, and so campaign finance, and also recently an attack on the Lanham Act and the In re Tam case, which will have some knock-on implications for the Washington football case. So something is happening. It's become a very popular claim, and let me just say something about why I think that is. I think that it's related to a couple of developments in commercial speech, and we can get into the weeds of that more later, and if you're interested in the details of that. But a couple of things that I think are happening is, one is a sort of equal protection-ish claim that regulation of commercial or corporate speakers is somehow discriminatory. So this idea that we should not discriminate against commercial speech, and then this idea about content neutrality that's become very sort of robust content neutrality argument that we saw in Sorrell versus IMS Health, and then also in the Reed versus Thomas Gilbert. We also have seen in the non-commercial area things like the rejection of decades of dicta about the value of false speech in the stolen valor case, so United States versus Alvarez, where the court decided that actually false speech might have some constitutional value, that the idea that had previously been recited in a number of cases, I think starting with Gerst, that false speech wasn't inherently valuable. It was more that we had to protect some false speech in order to get the good stuff. That is a fairly big departure from, I think, the past. And what we see also is a kind of merging of or application of the strict scrutiny standard and the approach in what you might think of as traditional First Amendment area into the commercial and corporate speech. Now, is it bad? The big question is it bad? Well, weapon is sort of a neutral term. Weapon, just, you can use weapon for lawyers do that, right? You can use weapon to fight for good, a sword for justice, that kind of thing. Lawyers don't make decisions when they're representing a client about whether or not this is going to be a good constitutional doctrine in the long run or not. They use the weapons and the arguments that are available. And these arguments are available and they're very powerful because the constitutional argument is kind of a game ender. If the Constitution applies and invalidates something, it's over. There's not too much of an end run that you can do around these things. So there's, in some sense, the title of my book, Brandishing the First Amendment, and the idea of weaponizing is simply a recognition that there is this application to a deregulatory kind of impulse. Now, is that a bad thing? Well, that depends on whether or not you think a deregulatory kind of trend is a bad thing. If you don't, you think it's great, and this is a great weapon that you've been having this opportunity to use. If you do think it's a bad thing, then you might be concerned about it. I tend to think that it's a bad thing. The reason I think, there are many reasons I think it's a bad thing, but one of the principal reasons is basically a conservative argument. That is to say, this casts a constitutional shadow on a lot of regulation that has been relatively uncontroversial for decades. And right now, we seem to be in a rather chaotic environment where we're not sure exactly what the limits of the commercial speech doctrine are, what sort of regulation is acceptable or not acceptable. And I will just say that I think that there is a very strong anti-democratic problem here in terms of the arguments for the sort of treatment of corporate persons as persons for purposes of the First Amendment or other contexts, because I think that it's certainly in the regulation of commerce, we didn't elect the boards of directors of corporations, and we don't have much control over what sorts of priorities that they assign in terms of social responsibility, or what sorts of things that they decide that might be appropriate to devote their money to. So particularly in campaign finance, I think that that's a relatively big problem. I think that some of the other things that I'm concerned about have to do with my expertise. I actually came from this as a litigator. I was a litigator before I went into law teaching, and I was really interested. I'm interested in expert evidence and the theories about persuasion. And some of what I see happening is this argument that as a pushing against expertise, so that all opinions are equally valid, and sort of the marketplace of ideas. The marketplace of ideas is going to sort out what the best ideas are. That might be fine in some contexts, and yet in other contexts, I think that we might be concerned about it, certainly with respect to things like pharmaceuticals or food labeling. We actually, I don't think, want to live in a world in which we have to try to find out by trial and error what the contents of a product are, or whether or not something's safe to consume. And that ultimately, I think, is some of the regulations around those kinds of issues may be threatened by this new doctrine. Now, having said that, it seems like the lower courts are somewhat reluctant to go as far as the case law seems to allow them to go, hence what I refer to as some of the chaos, because I think that the most recent case law would seem to do away altogether with the commercial speech doctrine on this content neutrality grounds. And let me just say why. The commercial speech doctrine is, by definition, a content category. That is to say, it regulates or refers to commercial speech as opposed to speech of other types. And so you have to first decide whether or not something's commercial to even decide whether or not the commercial speech doctrine applies to it. To the extent that that has been attacked, or at least there's been a suggestion in the Hurley case that that is an illegitimate sort of distinction, I think that that could be very problematic.
Thanks. So you've made a good case that we come at this subject at a moment when the tectonic plates are really shifting. I mean, commercial speech is not an age-old understanding of the First Amendment. It comes, if my history is right, it arose basically in the 1970s and is now kind of being re-sorted out. And I want to invite Professor Reddish to come in here and give me his thoughts.
Well, Linda, you're absolutely right. The First Amendment, you and I are old enough to remember, had a categorical exclusion of business from the protections of the First Amendment. It was sort of a spillover from the post-New Deal, anti-Lochnerism kind of approach. And I saw this most forcefully when I wrote my very first article, which was my third-year paper at Harvard Law School, published in 1971, entitled The First Amendment in the Marketplace, arguing that as a matter of First Amendment theory, commercial speech deserved significant First Amendment protection. And this was not received well. People keyed my car At Harvard, people pushed me into the lockers, and that was just the professors. And I understand that there are intuitive, ideological preferences that kick in, that view any kind of protection of speech that is related to commercial advancement or corporate advancement is a kind of creeping Lochnerism. But if there is only one thing my First Amendment students learn, and sadly I often discover there is only one thing they learn, it's that the First Amendment is not a strategic outgrowth of one's ideological agenda. What I tell my students is, if your constitutional analysis comes out to a conclusion that you ideologically agree with, immediately go back and rethink it. I'm trying to take you out of your comfort zone, where it's so easy to say, we don't like big business. Well, I don't particularly like big business. The only time I ever voted Republican was when I wrote in Abraham Lincoln's name in a gubernatorial election in Illinois, figuring 130 years dead, he was still better than either of the choices. I was a Democratic precinct captain for 3 years on the North Shore of Chicago. The only reason I resigned is that I wasn't promoted to precinct colonel. So this isn't about politics. The question is, what is the essence of the First Amendment? What is it about? And how does that apply in this context? So first, let's talk about the shock that everybody felt that a corporation could have a First Amendment right. Corporations, since the beginning of the nation, have been protected under the Constitution. They have been citizens under the Diversity Clause. They've been protected by the Dormant Commerce Clause. They've been protected by the Equal Protection Clause and the Due Process Clause. They have Sixth Amendment rights. They have Seventh Amendment rights. Why is it a shock that they have First Amendment rights? And if they don't have First Amendment rights, I am yet to be convinced why the New York Times and the Washington Post, which are profit-making corporations,
Hopefully.
have First Amendment rights. Well, aspirationally profit-making corporations. The fact that they are covered by the freedom of the press rather than freedom of speech has no logical principled connection to what the commercial motivation for the speaker is. The best indication of how the commercial speech doctrine is really ideologically driven is to look how the court has defined it. It is not defined as objectively speech about the competing values of commercial products and services. It's defined as speech that does nothing more than propose a commercial transaction. So if Ralph Nader criticizes the Chevy Corvair as dangerous, he gets full First Amendment protection for that. If General Motors tries to argue back that, yes, it is safe, they get, most people here probably would say, no protection. That is not just a categorical distinction. It is outrageous content viewpoint-based discrimination. In no other area of the First Amendment is a speaker's level of protection reduced because of a personal motive of self-interest. When people oppose tax raises, they are looking out for their self-interest. When unions support increased tariffs, they are looking out for their personal interest, and there's nothing wrong with that. Why all of a sudden, when there's a capitalist motivation, is there a problem with that? We have to remember that the First Amendment is designed just as much to advance the interests of the listener as of the speaker. If that's true, then what possible difference could the motivation of the speaker make? Now, are there times where, as Tamara said, safety is involved? If a compelling interest is shown, commercial speech can be regulated, but that's true of all speech. Why should commercial speech or corporate speech receive less protection? This has nothing to do with how one feels about corporations or ideologically or economically. The question is, what is in the interest of the First Amendment? And uninhibited, robust, and wide open is what the First Amendment is supposed to be. Having corporations speak contributes to that. If you think about the Citizens United case, what were we dealing with there? We were dealing with a movie about Hillary Clinton at a time she was running for president. What could be more central interest to the electorate, the more central to the First Amendment than that? But it was being promoted by a corporation. So therefore, we lose First Amendment protection. It seems to me that in this instance, the cure is considerably worse than the disease.
Okay, I'm going to give Tamara a chance to respond, but not yet.
Okay.
Because Marty ended by referring to Citizens United, and I want to give Dan a chance to talk about the First Amendment in the election context. And I know among the thoughts that you want to elaborate on, or that concern, as some of us might be, about invoking the First Amendment where we might think it doesn't belong, there's a problem on the other side of the coin. How about First Amendment interests that are going unrecognized?
Yeah. Thank you so much, Linda. Well, let me first thank ACS for having us all here. It's a delight to see such a packed room for such an important topic. Let me begin by saying that I have really serious reservations about the framing of this as weaponization of the First Amendment, which, as you suggested, Linda, in your opening remarks, implies that something sinister is going on. This isn't to say that I agree, as will become evident in a moment, with everything that the Supreme Court, especially the Roberts Court, has done in the realm of freedom of speech. But I do think it is rather dangerous, especially at a time when we have someone with strong authoritarian tendencies who will be a major party candidate for the presidency and who has talked about imposing restrictions on the media and other critics of his that would run afoul of our First Amendment tradition. I think it is dangerous at such a time to cast freedom of speech in the role of the demon or villain. Now, that said, I don't agree with everything that the Roberts Court has done, and as your question prompts, that is especially true in the realm of campaign finance. So what I tell my students when I teach First Amendment law is that there are really two big questions in every First Amendment case. One is, how strong is the speech or association or religion interest? Right? And the court, as it turns out, over the course of many decades, has developed different standards that apply in different contexts, depending, at least in part, on the strength of the speech or association interest. Commercial speech being an example of an area where the court has seen the value to be less and the reasons for regulation stronger, and therefore traditionally has, quite appropriately, in my view, in contrast to Marty's, afforded commercial speech a lesser degree of protection than some other areas. The second question that arises in virtually every First Amendment case: what are the interests on the other side? If you teach a course on the First Amendment, it's really as much about those interests as it is about the speech interests, be they national security or access to abortion clinics or reputation or freedom from corruption or political equality. And to my mind, where the Supreme Court, not just the Roberts Court, but at least in the area of campaign finance, going back 40 years, has gotten it wrong, is not so much on the first issue, is there a speech interest, how strong is it, but on the second, a failure to recognize the values on the other side, and in the case of campaign finance regulation in particular, failing to recognize that there are First Amendment interests on both sides. So, the bumper sticker criticisms of Citizens United that we've heard over the past 6 years. Money isn't speech, corporations aren't people. Okay, well, literally true, but I guess I'm with Marty here. I don't really think those are very good arguments. In fact, let me go further. They're affirmatively bad arguments, right? Yes, it's literally true that money isn't speech, but money enables speech. That actually, for campaign finance reformers like me, is why we got into this business in the first place. Because those who have a lot of money to spend on political campaigns have a lot more influence than the rest of us. Not just or even mainly influence on how elections are decided, but on what happens afterwards. People who are giving or spending hundreds of thousands, even millions of dollars to influence not just presidential, but congressional and state legislative and down to local legislative races, they've got access to elected officials, and they have a lot more influence on what happens after Election Day than the rest of us. And yet, for 4 decades now, since the court's 1976 decision in Buckley versus Vallejo, the court has taken equality off the table completely as a value that can ever justify restrictions on political spending, saying in Buckley, the concept that government may restrict the speech of some in order to enhance the relative voice of others is wholly foreign to the First Amendment. And the mess that we've got today, which, by the way, raises concerns about the very existence and sustainability of our democracy among people across the ideological spectrum, is at least in part attributable to what the Supreme Court has done. What I say sometimes is equality has become the Voldemort of campaign finance law, right? It is the word that must not be spoken. If one so much whispers that equality or leveling the playing field is the reason for enacting any regulation of campaign finance under the current, or at least the court until, as it existed until Justice Scalia's death, would almost certainly strike that regulation down as impermissible.
As the Roberts Court has in recent years.
Yeah, and that applies not only to restrictions on contributions, like were at issue in the recent McCutcheon case, and spending as were at issue in the Citizens United case, but also public financing in the Arizona Free Enterprise case. Public financing, a subsidy for speech. So that's the bad news. Here's the good news. We are just one vote away from a very reasonable jurisprudence of campaign finance regulation. There were 4 justices in the McCutcheon case a couple of years ago who signed on to a dissent penned by Justice Breyer, which recognizes that there is, in fact, a First Amendment interest on the other side. The interest in accountable government, in the people we elected to office being responsible to our needs, all of our needs, rather than just the wealthiest contributors and donors. And the 4 dissenters in their dissent in that case actually said, importantly to my mind, this is an interest rooted in the First Amendment itself. So, I think there are problems. I agree with some of the concerns, especially about commercial speech that Tamara has expressed. But at the same time, I would entreat all of us to resist the urge to make the First Amendment the enemy, rather than See, no, and I know you didn't say it. I'm not, right?
I didn't.
Okay.
So.
Fair enough.
I thought I heard you say that.
But I know you think that.
Look, when we talk about weaponizing, when we talk about brandishing, there is an implication there that it's a bad thing. And I really think at this moment in particular, that is not the kind of argument that progressives should be making.
So, Paul, I'd love to hear from you as a litigator. Tamara made the point that, it's the job of a litigator representing a client to use any weapon at hand, no matter what. So tell us about your life as a First Amendment litigator and what you think of this.
Well, it's not so much about my life as a First Amendment litigator, but I think the insight that people make some of these arguments that show up in books about the weaponization of the First Amendment because they have real clients who have real problems is true. I mean, and Floyd Abrams has brought dozens of these cases about GMO labeling and the rating services up in New York that rated the bonds and claiming First Amendment protection for the judgments that they made, even though they presumably were quite deceptive in some sense. There is an increasing set of government regulations which real clients are trying to deal with, and they tend to end up being targets of First Amendment claims where you have that available. And so I think there is a sort of natural hydraulic process that real client interests in this area, and as in many other areas of the law, end up pushing lawyers to make arguments that law professors would say, well, gee, if I were kind of just not representing clients, I wouldn't think that was the best argument to make. I could talk about other aspects of what's been going on here if you want, Linda, but that's... I thought I would talk a little about the union stuff, if that makes sense at this point.
Please.
Yeah, there's an interesting, the thing that's been missing, I think, from this discussion. I think perhaps to my mind, one of the really glaring examples of abusing the First Amendment, the Supreme Court abusing the First Amendment, is this series of cases that came this close to taking down the agency fee that is paid to public employee unions, the basic Abood compromise that was struck 40 years ago.
Talk about a deus ex machina, huh?
Boy, no kidding. I'm sure a lot of you know all about this, but basically the compromise that was reached 4 decades ago was that people who join the union can pay all the dues that the union imposes on them. People who don't support the union but are still getting the benefit of the collective bargaining and of the grievance procedure representation that the union is required to give to everybody in the bargaining unit, whether they like them or not. They could pay a lesser fee, which is called the agency fee, which covers just that portion of the union's functions. And the insight that was reached then was that while you are in some sense being required to pay your money to support an institution that you don't approve of, they're giving you direct services that give you direct economic benefits. Nobody is being really labeled as a supporter of the union who isn't a supporter of the union. They just know you went to work in this particular part of the government. And so there isn't much, there may be some, but there's not much First Amendment injury to requiring people when they voluntarily take a job in a public sector to pay the fee that supports the union, particularly since the government, at least in states which strongly support these unions, the government is happy to have a strong and healthy partner to negotiate with over contracts and to have represent the employees in a productive manner in grievance procedures and stuff. And so that's the compromise that was reached, but led along around 5 years ago or so, the Supreme Court kind of sua sponte decided that they were going to take this on in a case called the Knox case, involving a rather narrow issue related to all of this. Justice Alito invites somebody basically to come bring a lawsuit that says this whole compromise needs to be upset, that it's terrible that people have to pay a dime out of their pockets to support the union. Such a case was then brought. I argued one of them called Harris versus Quinn, where the court came this close to getting rid of the agency fee, but ended up deciding it narrowly on the ground that it couldn't be extended to the context of home health care workers who in some sense were employed by the individual recipient of care, in some sense were employed by the state, and they said, well, at least in that context, we're not going to extend it. But they couldn't get the fifth vote in that case to throw the whole thing out. And understand that what's really going on with this is the public employee unions are a very important part of the Democratic coalition. They have an enormous amount of expenditure of time and energy on political campaigns. And, I think that is clearly what's in the background of all of this push. There is also, I think, to be fair, a conservative critique of public employee unions would basically they make a nefarious bargain. They basically make contributions to the Democratic office holders who then negotiate contracts with them are very favorable using public money. And so you end up, a conservative would say, with public policy being made badly because the unions support the Democratic politicians, get them elected, and then they turn around and give them big pensions, which Illinois can't afford to pay. And there may be some truth to all of those views, but the truth of the matter is, I think that the basic First Amendment attack being made on the agency fee is clearly just abusive. That it makes little sense to think that when someone voluntarily accepts a public employee job, that they have to take $30 a month out of their check to pay for the grievance procedures and the collective bargaining that raises their wages and benefits every year. That's a major First Amendment violation seems kind of silly. Fortunately, what happens in the Friedrichs case is they're about to completely lower the boom. Our case has been argued, it's being written, we lose one of the justices. And so it now looks as if, unless something goes very awry in the presidential election, we will not have a fifth vote to lower the boom on the Abood line of cases, I would think. And so the future of this particular section of the labor movement looks very different. But I would just close with, I keep emphasizing that people voluntarily take these jobs. People, when they take public employee positions, give up lots of First Amendment rights, much more significant ones, I would say. If you've read the Garcetti case, written by Justice Kennedy, a great First Amendment stalwart, it basically says you can be punished for, and you can be retaliated against for speaking on an issue of public concern if you're doing it in your capacity as a public employee. In other words, in that case, there was an affidavit that this senior prosecutor thought was being misused by the prosecutors, that it was inaccurate and it was a basis for a prosecution that should not have been done. He complains about it internally, tells people that this is a terrible thing, we shouldn't be doing this. He gets retaliated against for it, he says, brings a First Amendment claim, and they say, you have no First Amendment interest in protecting the speech that you make as an employee, even though it's a matter of core First Amendment interest, because you're doing it as an employee, and you give up lots of First Amendment rights as an employee. So I'm standing in front of the Supreme Court. I'm about to be, my red light's about to go on. I keep saying, this is really not that big a thing. You make people pay this $30. And Justice Kennedy turns to me and says, do you mean to tell me that you think people give up some of their First Amendment rights when they go to work for the government? And I'm saying to myself, Justice Kennedy, really? I mean, come on. It was
What did you say, Paul?
I said Garcetti is what I said. But it didn't seem to take. It really is astonishing, actually, how blind spots that the justices have on some of these issues. So at the end of the story is I think a really terrible effort to misuse the First Amendment is ended in nothing, at least for the moment.
In case people didn't follow this Friedrichs case, maybe I'll just give you a sense of how openly activist the Supreme Court and people who wanted to enjoy the Supreme Court's warm embrace on this matter have been. So after Justice Alito couldn't quite get what he wanted in the Quinn case that Paul was involved in on the other side, a group of anti-teachers union folks in California cobbled up a challenge to the agency fee in the context of the California Teachers Union. And they went into federal district court and they said, please rule against us, the plaintiffs said, as quickly as possible, because we want to send this case to the Supreme Court as quickly as possible. And of course, the district court did rule against them because Abood was still good law on the books. So they went to the Ninth Circuit and they said to the Ninth Circuit, please rule against us as quickly as possible so we can get our cert petition up to the Supreme Court. And of course, the Ninth Circuit obliged them. And it was just the strangest thing. There was really almost a lack of adversary interest in that case, but there was such an appetite that it just kind of, reminded us the stakes were very high. And, as I said earlier, the tectonic plates were changing, and these plaintiffs thought that they could come in.
Can I just speak to that issue? I know Tamara wants to get back to the issue we discussed, but I want to get on the table of my views on Harris and Friedrichs, because I have very strong feelings on it. I think Paul's absolutely right. It's outrageous use of the First Amendment as union busting. Basically, there's a distinction, there's a cognitive, active distinction for purposes of the First Amendment. You cannot be forced to associate with ideas that you don't like. That I definitely agree with. But because you don't like the idea doesn't mean you can't be forced to associate with the activity. You may think public accommodations integration is outrageous. You have every right to think that. You have every right to say that. But because you think it doesn't mean you can engage in the act of not participating in integration. And it's the same thing with collective bargaining. You may hate the idea of unions. You may think they shouldn't have authority to collective bargain, and nobody can stop you from saying that. Nobody can force you to associate with the expression of that as an idea. That doesn't mean you can't be forced to do it. And that this is outrageous union busting is revealed, I think, by the state of Illinois' amicus brief in Friedrichs on behalf of our beloved Governor Rauner, where they argued simply that unions are evil, that all the horrible things that public unions have done, and that's supposed to have something to do with the First Amendment. And I knew one of my best former students was Rauner's top legal assistant. So I called him up and perhaps wasn't subtle enough. I said, "Did you write that piece of garbage?" And he said, "Yes, frankly, I did." I said, "I'd like to talk to you about it." And he said, "We'll have to have lunch someday." And that was a few months ago. I have not heard back from him. But this is one area where I think the Roberts Court has just been transparently and blatantly result-oriented, and the First Amendment is being soiled as a result.
Tamara, your turn.
Yes, well, I think my point has been proven as a descriptive matter. We see some articulation of the way in which it's being used as a weapon, and I really, truly say this is the hydraulic sort of process is one that I think there's a commercial, or there's a lot of money, if you will, that's oriented towards trying to get these sorts of results, and there's not as much money devoted to the other side. But just in the ideological, intuitive claim, I just want to, this one of the interesting things about this development and about the current First Amendment doctrine is how it has completely flipped the ideological and political sort of designations from 30 or 40 years ago. So the person who made the pitch that the expansion, the commercial speech doctrine was an expansion, a deregulatory tool, and was reinventing or was resurrecting Lochner, was that well-known enemy of capitalism, Chief Justice Rehnquist. So, I mean, he was not, I think, by any stretch of the imagination, a liberal or expressing an ideological opposition to the commercial speech doctrine. He was expressing, or perhaps he was, I don't know, I don't have any, mind melds, but I think he was expressing as a concern that if we took this seriously, if they took this doctrine seriously, that there wasn't necessarily any internal stopping point. Now, having said that, the First Amendment's full of all sorts of line drawing exercises. One of them is around this corporate identity. And, again, a lot of corporate law scholars are on the side of this illogical definition. The Austin versus Michigan Chamber of Commerce was a very granular, very fact-sensitive decision about whether or not we can treat this as more like a corporation speaking or more like a nonprofit. 501c3, 501c4, the tax code makes distinctions around what type of corporation is it in order to identify tax status. Corporate law is nothing if not formal, right? It's because there is no there for a corporation except what the law organizing it says, and the law that organizes it says what its purpose is. Now, if you want to talk about corporate law has gone to a sort of general business purpose in order to allow corporations to do virtually anything, including media companies or companies to own media in ways that they didn't before. But one of the things that's so interesting about this development of the First Amendment is its asymmetry. So on the one hand, we see these attacks, or what perhaps that sounds like demonizing. I'm not trying to demonize it. We see this aggressive use of the First Amendment to strike down some regulation. On the other hand, aggressive use of the First Amendment to try to protect property rights and property interests in trademark and copyright, trying to push back on fair use. So and you know, it just really takes a special kind of chutzpah, I think, to say the First Amendment is, you know, the government's putting a thumb on the scale and making a decision about which side it favors when it refuses to give trademark registration to a disparaging, you know, name or disparaging mark, so that the owner of the mark will have the right to suppress other people's speech. So, I mean, that's basically what trademarks do, right? Is they enable the owner of the trademark to be able to stop other people from using it unless they get a license, unless they pay them a fee. And the whole purpose for trademark, the whole intellectual underpinning of trademark was consumer-oriented, not oriented towards the property owner. It was oriented to the idea that consumers could rely on the mark as a symbol of quality or the product that they wanted and so forth. That's exactly the same rationale that was given for the commercial speech doctrine, that the consumer, the listener, had a First Amendment right in hearing accurate information. And the threshold requirement for protection, the thing that made it protected, was the very thing that in traditional First Amendment area you're not supposed to do, which is that it be truthful. Truth tests are, you know, discouraged in most cases. So traditional First Amendment, strict scrutiny, New York Times versus Sullivan, you have to meet this actual malice standard, and that the standard actually protects a lot of false speech because, as Justice Brennan says, we need some breathing room, you know, to get the good stuff, so to speak. But that was supposed to preserve things like libel and so forth, and but the content of libel still nominally has some possibility for bringing these kinds of tort cases. In contrast, in commercial speech, if it was false, it wasn't protected at all. So false speech didn't get any protection, and commercial speech had to be true to be protected. If you go to a content neutrality construction, and you say that singling out, as the court did in Sorrell, and you know the Knox case is not the only sort of aggressive. Citizens United itself was relatively aggressive. If you take the position that the court did in Sorrell, that the state of Vermont's attempt to prohibit the sale of prescriber-identified information of pharmaceutical drugs for marketing purposes as opposed to some other purpose like research, law enforcement, is content discriminatory, then I don't understand how you can have a commercial speech doctrine at all, because it would seem that commercial speech is itself a category of content. So, and it is so eloquently actually explained by Marty in his comments.
You want to weigh in?
Yeah, I agree with you on your discussion of Sorrell. Once you accept Sorrell, the commercial speech doctrine as it currently exists, and I should emphasize this is not your father's commercial speech doctrine. Commercial speech receives a significant level of protection, but Tamara's right, not the equivalent of non-commercial speech. So once you accept the Sorrell logic that discriminating against commercial speech is a form of unacceptable viewpoint or content-based regulation, then the court's commercial speech doctrine itself is a violation of the First Amendment. We have met the enemy and he is us. So there's an inherent illogic. I think Tamara and I go different ways as to how that illogic should be reconciled, because I think the court was right in Sorrell. The state
Can I
legislature.
just interrupt you?
Sure.
In case people don't have a very detailed knowledge of that case. Do you want to just describe the facts of Sorrell? Because it was such an inflection point in the Roberts Court, it's worth just drilling down on it a little bit.
Sorrell dealt with data mining, where drug companies would get bulk prescription information by doctor. They'd get no names, but they'd find out what drugs doctors had and had not been prescribing by buying this bulk, large information from drugstores.
They had the doctors' names. They didn't have the patients' names.
Right. That's what I meant to say if I didn't.
And the reason for this was so that Big Pharma could then go to these doctors and say, don't prescribe that cheap generic. We have a brand new drug that, will serve your patients well.
Well, I think that's a little pejorative. What if I didn't know better, Linda, I think I'd know where you come out on all this.
I'm just laying it out.
Yeah, well, they would send their representatives to the doctors and say, I notice you haven't been prescribing X. Are you aware of what X might or might not do? So the state legislature banned this process, but in doing so, it left open the possibility of data mining if the use of the information was for a purpose other than commercial marketing, if it was for academic research. And the court found this to be the equivalent of a viewpoint discrimination. The state legislature didn't like drug marketers, they liked academic researchers, and they were drawing a distinction that wasn't justified, a problem that wouldn't have had existed had they simply banned everybody from using it, but they didn't want to do that. So the court basically applied the classic viewpoint regulation logic to this kind of restriction, subjecting it to strict scrutiny. And if that's true, then the court's own doctrine giving lesser protection to commercial speech than to non-commercial speech is itself a violation of its Sorrell doctrine. And the court seems not to have recognized this, shall we say, awkwardness.
I don't think really it was that they didn't like the market. I think that the state of Vermont wanted to reduce the use of brand name versus generic drugs. They wanted some doctors felt like it was a privacy violation to have, it's a well-known, this Robert Cialdini writes about persuasion and marketing, has said it's a well-known technique of marketers to try to extract, and they'll do this and get out the vote efforts, try to extract a promise from the target that they will do something or other. If you extract a promise, people are more likely to follow through. So marketers, detailers try to extract a promise from the doctor that they're going to prescribe this in the next visit. This allows them to discipline them or to find out whether or not they fulfilled their promise. Doctor, I noticed that you actually didn't prescribe any more of, Effexor or whatever it is. That I thought you were going to write that for your next 10 patients. This is, that's the kind of thing that helps them be more effective, since the marketers don't actually leave the product with the doctor on the visit.
So turning back to election law, Dan, are there any cases in the pipeline that are going to give a new court a chance to correct some of these mistakes?
Yeah, so I think on campaign finance, as I mentioned earlier, really everything depends upon who the new justice is. We have seen in the past and are sure to see in the future challenges to BICRA's soft money ban. That's the restriction on previously, before McCain-Feingold, monies going to these various party committees that were essentially used as an end run around existing campaign finance rules. It seems to me that the logic of the McCutcheon case would actually require that the soft money ban be struck too if we had the same court. Turning to other areas, and this gets me back, Linda, into an area where I actually think it's not that the Supreme Court has seen First Amendment issues where they aren't, but has failed to see them where they are. Some of the recent voting cases we've seen arising in various places, like Texas, which enacted a strict voter identification law, North Carolina, which right after the Shelby County decision enacted various restrictions on voting, including voter ID and limiting voter registration, including my state of Ohio, where we've seen over the years repeated attacks on the right to vote. I see some of my Ohio students in the house. This is just something we do. OH? All right, good.
I can't believe you actually did that.
You know, Dan,
Evil.
this is being recorded.
I know.
Get a grip.
We're sharing the Buckeye love with all of America. We didn't plan that, by the way. So, but what's interesting here is the Supreme Court in the past has, in some cases, recognized that the right to vote is a form of protected association. It hasn't exactly said it's speech, but in cases involving ballot access and discrimination actually against both minor and major parties, the court has recognized a First Amendment interest here. Interestingly, the test that the Supreme Court and now the lower courts have applied since the Crawford decision, the voter ID decision, is borrowed from First Amendment law, only we've lost the First Amendment associational rights dimension to it. What these cases are really about at their core is the dominant party discriminating against the non-dominant major party by making it more difficult to vote. And I actually think that our voting rights jurisprudence would be enriched by recognizing the First Amendment connection.
And another issue that in election law that's bubbling up, I know, is new cases involving redistricting.
Yeah.
The court just took one.
Right.
Are there First Amendment implications in those?
Yeah, and Paul and I were talking about this actually just before the panel. He was involved in the Veith litigation, where Justice Kennedy has this. Justice Kennedy, as you may recall, was the swing justice in the Veith case. We had 4 justices led by Justice Scalia saying these are non-justiciable cases.
That was on gerrymandering.
Right, on gerrymandering, sorry. And 4 justices offering various standards, dissenting and saying there is a claim here. Justice Kennedy in the middle saying plaintiffs, those challenging a partisan gerrymander, lose without offering a standard, but suggesting, well, I don't really like your equal protection arguments, but there may be a First Amendment claim. It was, as is his wont, very vague. I think there's some possibility of giving some content and form to these nebulous ideas that Justice Kennedy expressed in his Veith concurrence.
There's actually this is kind of off the point a little bit, there is actually a whole series of cases being filed now to try to revive the partisan gerrymandering limitations, and partly they invoke the First Amendment, although you can do it as an equal protection case with heightened scrutiny using the First Amendment, or you can call it anyway. But what they've really done is these professors have come up with various mathematical tests to try to actually measure the degree of bias in the maps and try to give the courts some comfort that they're not just going to be left at sea, which is what the conservative critique of partisan gerrymandering claims has always been. There's always been a recognition that some amount of partisan discrimination in maps is legal. So how do you know when you've gone too far? You end up with kind of an obscenity test. I know it when I see it. That's not really good enough in a bunch of political cases.
And will these come up directly from 3-judge courts, or where are these cases?
The case was just tried in 3-judge court in Wisconsin, involving the unbelievably gerrymandered state legislative map in Wisconsin. So,
and there's also the Shapiro case, which arose out of Maryland, and the Supreme Court said this past term that it has to go to a 3-judge panel. So that case is percolating up as well. That one involves a Democratic rather than a Republican gerrymander.
Well, I think we've kind of surveyed the landscape here, and I'd like to give people a chance to ask questions, if they have any, which I assume people do, at the mic there. And just let us know who you are.
So my name is Robert Parker. I'm a student at Lewis and Clark Law in Portland. And I just have a question because through a lot of the conversation, it seems that just underneath the conversation, there's this presumption that we need to have some sort of that we need to do something about speech from corporations to protect the all-powerful corporations from the unwitting consumer. And growing up with the amount of information that I have available to me, it seems like I'm much more concerned about protecting corporations from themselves now that we're so much more sophisticated. You talked about how the freedom of the press, we give freedom of the press to say whatever they want to say. Well, that may be true, but nobody believes Fox News anymore because there's so much of a driven agenda that when...
Has Fox News said something incorrect?
Well, I think we've heard the statistic that out of the people who can state factual statements, the people who watch the news are the most factually knowledgeable, and then people who don't watch any news, and then people watch Fox News are sort of the bottom right now. But the difference is that we know that. And when somebody says, well, I saw this on Fox News, we just sort of stop listening to them. And that's an example of something we've already seen of the press hurting itself, because we actually need differing viewpoints, and we can't trust them anymore, and we used to be able to. And I think the same thing is true with current corporations. You mentioned why can't GM fight back? Well, because I think we want the people that make our cars to tell the truth. If Volkswagen had the freedom to say, all of our cars meet all of the industrial standards, we've checked them ourselves, you don't have to double check, trust us. If they were allowed to just say that and that became truth, then there would be absolutely no reason for them not to lie, because there is that profit motive, and there's just sort of a race for the bottom.
So your question is?
My question is that really true, that we're more worried about the unwitting consumer? I think the consumer's fine. We're too smart to be fooled by that. I'm more worried about the corporations.
I think that we actually could be worried about both. I don't think that knowledge is always power. I think we've got a lot of cultural investment into that idea about disclosures, and knowledge is, with respect to advertising. But let me just underscore or support your point about corporate. Having worked in corporations before I went to law school, and thanks, I would say that one of the arguments I've made is that you need to give corporate counsel some reason to say you can't do this, that there's some limit for, and I'll give you the best example of exactly that sort of tendency, native advertising. Native advertising, for those of you who are not familiar with this term, it's a term in advertising that refers to, putting up content that looks like content, but it's actually an ad, so it's sponsored content on digital platforms. And I have said that actually, the reason that advertisers want to do this is they want to borrow the, quote, credibility of the press, except that if they succeed, once people have the same attitude of distrust that you reflect towards all the content, then all they've done is actually eliminate the reason why they wanted to dress as content in the first place. And so now we're all, this is a suicidal sort of system. Having said that, I think probably everybody on this panel would say we don't want the government, regulating Fox News or, like newspaper news reports. So, but we're in a really terrible place right now, and I don't know exactly what the answer is, but that traditional sort of line between commerce and, political expression or artistic expression is one that seems like we should try to reinstate, I would say.
I would like to say something about the corporate media, since that was raised. I find it ironic that when I watch Rachel Maddow, whom I love dearly and watch regularly, and she rails against Citizens United, and I'm thinking, you're up there getting paid big bucks by Comcast, so you can speak with at least the acceptance, if not the approval, of a large corporation. Yet you want to deny other corporations a similar right, because basically you're asking for a corporate speaker monopoly. If the corporate world can so control the media, why can't a non-media corporation publish its own magazine, have its own blog? Why is that not as much freedom of the press? Because we don't like their economic views? Ask yourself, is that why? Or can you come up with a more principled distinction? I'd love to hear it.
Sir.
Good afternoon. I'm Howard Wayne from San Diego. And my What I'd like to ask is the following. A frequent participant in this conference has written a book that argues the First Amendment is not just a recitation of 6 rights, but has to be read as a whole, as a democracy proposal. How would you, or what is your take on that argument?
So I have read the book, but that is the perspective from which I'm approaching this. I do think that, and there are different schools of thought on this, right? There's a school of thought that the First Amendment is mainly about autonomy, but I tend to be of the democracy school of the First Amendment. I think that is really what the First Amendment is there for, and that speech regarding politics and elections and the political process is therefore deserving of the highest level of protection. And that actually is what I genuinely think makes the campaign finance cases so hard. Look, there are really important speech interests in being able to spend money to run an ad or to give money for a political campaign. I think there are, and I know there are some people who might disagree with me on that. I guess I also I also agree with Marty that just because the source of the speech is a corporation doesn't mean that it should be denied protection. If it were really the case that corporate ideas were excluded from the marketplace, right, then I think we would have a problem. Where I think the court has really fallen down on the job, however, is in failing to recognize the democracy interests, the self-government interests on the other side, but we should take heart in the fact that Justice Breyer actually has in his McCutcheon dissent, and if we get one more justice on this court, one more good justice on the court, there's the possibility of rehabilitating our campaign finance law, at least, and maybe some of the other areas we've touched on.
What was so interesting about that dissent, just a quick comment, Linda, is the way he used the anti-corruption rationale, which is the permissible rationale since Buckley, and wove it together with an idea that there's a First Amendment interest in being able to speak to the people who govern you, even if you only give $10 and you can't give $10 million. And that, so the equality idea is sort of coming in through and being merged into the anti-corruption idea, that the idea that the people who govern us are too beholden to the major donors. And it was, I thought, an extremely interesting and very thoughtfully written dissent, whether you completely agree with it or not. And I end up being on the fence on these issues all over the place. I tend to think, well, contributions you should be able to regulate, but not expenditures. But that makes no sense. And it's really, I find these very difficult issues. So,
can I say a law that says no one is allowed to say anything about anything, anytime, achieves equality. Clearly, there is much more to the First Amendment than the concern about equality. To suppress communication because one side has more ability to communicate than the other does not increase information to the public. It simply means the public is equally ignorant about both sides. And often, one side that doesn't have the money has other built-in advantages coming from Donald Trump, Arnold Schwarzenegger, John Glenn, Ronald Reagan, coming from pre-existing fame or notoriety that can only be equalized by the expenditure of money. To demand a myopic equality of one qualification or one strategic device basically misleads or distorts the allocation of communicative power. The 1971 Campaign Spending Act was laughingly referred to in the halls of Congress as the Incumbents Preservation Act, because incumbents had a franking privilege. They had an enormous built-in advantage over challengers, and the only way a challenger could often compete is if they were able to spend more money. So the concept of equality here is so much more complicated than just money, and I'm afraid there's a significant distortion of the equality interest if all we focus on is one element of that analysis.
I think that's right, but at the same time, the interest of the First Amendment isn't just in maximizing the value of the speech, and this is the really important point that Justice Breyer makes in his dissent. It's also about having a fair political process in which the wealthiest voices don't dominate, and yet that is, in the view of many of us, the political process we have today. And that is an interest that is, as Justice Breyer writes, rooted in the First Amendment itself.
Let's take another question.
Hi, thank you. I'm Jessica Piccolo. I am a legal analyst and vice president of Law and Courts at Rewire News. And I would like to shift this conversation a little bit because I've really appreciated the focus on finance and spending and its democratizing purpose and role. But as everybody here knows, the First Amendment is a lot broader than that. And in the area that I work in, I see an elision of First Amendment principles coming in the form of objections to contraception coverages, to objections to associational rights with reproductive health care providers. And so since we're talking about weaponizing the First Amendment, I just wanted to broaden that a little bit and say thoughts there beyond election speech.
Well, I mean, that's part of what I mentioned at the outset, and I think, as I said, lawyers use the arguments that are available to them. This argument seems to be very compelling. I think part of the reason for why it's compelling has to do with something that Linda said in the outset about First Amendment and the idea of equality being sort of first support for the First Amendment being kind of something that we might reflexively salute. I had the bad judgment to write an article called Against Freedom of Commercial Expression, which, the short title ends up being Against Freedom.
Did that give you pause, perhaps?
But I think, that idea, this is the content-speech distinction, which some are trying to use as a hook to try to save the expansion of Reed, of the content neutrality in Reed, is not a helpful distinction. I mean, for years, O'Brien was identified, this is the armband or the draft card burning case, as conduct, and many people mocked that as, well, that's just that's not a if we wear an armband is conduct or a sit-in is conduct and so forth, and that there's a lot of expressive conduct that we wouldn't want to regulate under that. I'm not sure I have a lot. One of the challenges of saying anything about the variety of areas is that I'm not a specialist in all of these areas, and all of these kind of siloed areas like securities law, pharmaceuticals law, election law are areas of specialty that people have studied and are in for many, many years, and there are many details to know about them that I think sometimes they don't realize that this same argument that's happening to you in the crisis pregnancy centers is happening also in securities law. It's also happening in pharmaceutical regulation, and that's part of the reason for trying to bring it up to sort of more of an overview.
Just a quick comment on this. Thank you for asking this question. This is, to go back to something Marty mentioned earlier, one of the areas in which the ideological polarity of the issue has really flipped over the years. I mean, you remember, 20-some years ago at the time that Congress enacted the Religious Freedom Restoration Act, liberals were big supporters of religious freedom at the time. Because we thought of it as protecting minority religious beliefs. Well, nowadays we see, for example, corporations that don't want to be compelled to offer contraception to their employees because of religious objections, making use of that act, and similar statutes at the state level. Of course, the wedding cake example, right? Companies that don't want to. So I guess I really think, going back to my framework earlier, this is one in which it seems to me, when we're talking about businesses that are selling products or being required to offer coverage, it's not that there's no interest there. There's no interest in religious freedom, but I think the interest in religious freedom has, at least in some contexts, been dramatically overstated, and even under the Religious Freedom Restoration Act doesn't therefore warrant strict scrutiny. The
irony about the religious freedom issue is if if RFRA hadn't been passed and we were just using the First Amendment free exercise clause, under Justice Scalia's opinion in Smith, none of this stuff would arguably be unconstitutional, because as long as you are treating the religious participants the same way you're treating everybody else, then there's no violation. So the irony is the conservatives, who are wrapping themselves in the religious freedom under their own understanding of religious freedom, this isn't a violation.
Yeah, so the whole trajectory of RFRA is totally fascinating. We could spend an hour on it, but we'll go to the next question.
Hi, my name is Amanda Knief. I'm the legal director for American Atheists, and I guess you kind of spun a little bit towards my question. We're seeing an increase with, especially, I hate to pick on them, Catholic hospitals taking over our healthcare system, and they're using their own religious beliefs to determine patient care, not necessarily what patients want, and using free exercise as the reason. So I was just wondering if you could talk a little bit about how now we're seeing free exercise not so much as to protect people, but using it as a weapon to determine how it's going to affect third persons, and not necessarily protect people, but corporations and their beliefs.
See, now I think this is a direct outgrowth of the rhetoric in Citizens United that suggested arguments now that we've heard of somehow invidious discrimination to treat corporations differently. And you know, when I say treat corporations differently, I mean different corporations ought to have different sort of status. So maybe perhaps a Catholic hospital or a Catholic university or a monastery is in a different situation than the Greens and Hobby Lobby. And you know, this goes to Dan's point about there being First Amendment, both expressive and free exercise issues on both sides. That what got totally written out of all of the Hobby Lobby was the interest of the employees in having a law, a general application applied, being able to take advantage of that law. But you know, I feel like that this idea of a corporation as a citizen or as an entity, this is kind of an anthropomorphizing of a fictional entity. And while there is, I mean, it's Milton Friedman, who's one of the, again, not an icon of the left, who has made this case that corporations have no business in social responsibility. They have no business in politics. Richard Epstein actually said this a while back. No, they shouldn't be interested really in politics except as, you know, rent-seeking. That, you know, this line of trying to keep business out of those areas, it seems to me it was a useful one to be able to enact legislation like that, to be able to serve a number of different objectives that is now being threatened by entities that actually have a whole lot more resources at their disposal. So if you think about the First Amendment, or if you think about protection for the dissenter and invidious discrimination as being in a majority system, we need some device that will allow people who are otherwise never going to get the majority, who are never going to be able to elect their candidate, who might be a despised group. We need some device that will protect them from oppression. The First Amendment and this idea of access to the court seems important bulwark of liberty. Is another thing altogether to hand that over to the, rather than a counter-majoritarian force, to hand it over to those who already possess a great deal of power and say, you know, we're going to, you know, amplify that power by treating you as a citizen. I mean, the McCutcheon case talks about voters and contributors, and I thought that was a really interesting sort of elision or addition. Since when is that a separate category, like voters and contributors? It's like contributors being equally important to the political process.
And what about the New York Times? I haven't heard your view on that.
Oh, no, I think I did say my view on that is that press corporations ought to be treated differently than, now, having said that, because we have a press clause.
We have a speech clause, too.
Yes,
You're sort of begging the question, aren't you?
No, I'm not begging the question. The speech clause also does not articulate every way in which we actually punish speech. So perjury, libel, contracts can be enforced. I mean, all sorts of, we have sort of a system that enforces the First Amendment and the speech clause that makes all kinds of exceptions.
We have it in the press clause, too, that makes the exact same. In fact, the Supreme Court has never distinguished its protection between speech and press. I guess I just don't understand the logic. Why the robotic profit self-maximizer has a press right when it doesn't have a speech right. There's no originalist argument for it. The modern corporation didn't exist until the Jacksonian period. It seems to me a rather arbitrary, result-oriented kind of dichotomy, so that you like big newspapers, but the evil corporations who foster capitalism, you don't.
Language about evil and demonic and stuff.
You don't think they're evil?
I don't think they're evil. I don't have any. I actually am. One of the fights that's happening in progressive corporate law, and I taught corporate law for a while, is about corporate social responsibility. And there are many people who are making really strong arguments, basically, I think in some ways surrendering the possibility that we can get this from the democratic process and from legislation, because we can't enforce this. We can't enforce truth claims on the corporations. They want corporations to be engaged in social responsibility, and so they make the argument, well, if corporations are people, then with rights come responsibilities, and so they can, but of course, the corporation's directors who are not elected by us are not going to be accountable to us, are making choices, and again, I will just, I'm going to quote now from Milton Friedman, the whole justification for permitting corporate executives to be selected by the stockholders is that the executive is an agent serving the interests of his principal. This justification disappears when the corporate executive imposes and taxes and spends the proceeds for, quote, social purposes, and in effect becomes a public employee or a civil servant, even though in name the remains an employee of a private enterprise. On grounds of political principle, it is intolerable that such civil servants, insofar as their actions in the name of social responsibility are real and not just window dressing, should be selected as they are now. If they are to be civil servants, then they must be elected through the political process.
No private speaker is elected by us or is accountable to us. To automatically declare these are civil servants, that they represent the government, I think undermines the basic notion of a private-public dichotomy. There's nothing making these corporations governmental entities.
I want to give Wendy Kaminer a chance to ask her question.
Sorry.
Thank you.
Sorry.
Wendy Kaminer, I'm sorry to say I'm a non-commercial writer. That's been one of the great failures of my life. And I wanted to ask a question about the difficulties sometimes of distinguishing between commercial and non-commercial speech. But first, I really have to make a point about corporate political speech. I think it's important to recognize that it is also a great benefit to ordinary people who can't afford to buy their own media companies and can't afford to write 6-figure or 7-figure checks to super PACs, because they speak through corporations. They can afford to spend $25 a month to a not-for-profit advocacy group, to the ACLU, to Planned Parenthood, to the NRA, to any number of groups. And virtually every citizen advocacy group is a corporation. And it's very difficult legally to find ways of distinguishing between not-for-profit and for-profit corporations.
The court did
Union.
for many years.
The court did for many years, and the tax code does. And I am arguing that you should.
Well, the tax code does, though the tax code is not enforced, and that's why we have a problem with dark money.
I would not apply that. I mean, we're not talking about corporations writ large. I'm talking about for-profit corporations. So
No, I understand that, and I'm just making a different point, that I think it's important to keep in mind that when we talk about corporate speech, we are talking about the speech of not-for-profit corporations, advocacy groups, as well as large business corporations.
I'm not, though. So.
If I might.
But can I just, I'm actually sorry I raised that, because
With this very interesting exchange between Tamara and Marty and your comment, illuminates to me that when we're talking about corporations versus individuals and distinguishing within corporations, it's really terribly important that we pay attention to the context, because the strength of the speech or association or religion right may vary dramatically. Going back to the Hobby Lobby example, I honestly think the religious freedom interest there for a for-profit corporation to be able to deny coverage. Pretty minimal. On the other hand, and here I'm agreeing with Marty, in the context of campaign speech, we're really focused not so much on the individual interest, but on the marketplace. It's a listener-oriented perspective. And if it were really the case that pro-corporate speech were diminished in the marketplace of ideas, well, then I think the court would have had a point in Citizens United. And I don't think we should have a distinction in this area that is based solely on whether the speaker is a corporation or an individual. And from that perspective, I agree with your basic point, if not some of the details.
Can I just ask my quick question about what you might think of as hybrid speech? When I think about the Lanham Act case, the Redskins case, and the team being denied trademark protection because Redskins is considered disparaging, and that's commercial speech, there are large media corporations that regularly publish books for purely commercial purposes, some of which have a lot of false and misleading information. I'm thinking, say, of, I don't know, junk science diet books are probably a good example. You might even think about Scientology, which reportedly Ron Hubbard wrote his first books and established Scientology as a commercial endeavor. Now, I don't think people who would agree that Redskins shouldn't be trademarked would want to say that we should discriminate when we hand out copyright protection between, say, a commercial diet book that's issued purely for commercial purposes and, you know, a book that just doesn't make very much money, or that does make a lot of money, or that's taking advantage of some sort of literary trend. So, you know, how do you deal with that? I don't think we ever had a real traditional line between commercial and non-commercial speech, especially if we think about the copyright area.
Well, I mean, actually, you know, you confuse, or you've mingled two things: copyright, which is in the Constitution and applies to books, and trademarks, which is not in the Constitution, I don't think.
No, I understand
yeah,
that, but I think the principles.
Well, but I mean, I think the principles are very different. I mean, the idea about copyright was the act. You know, again, I'm sort of straying into intellectual property, but I mean, I think part of the idea of copyright was that you need to incentivize the producers of art, of literature, of, you know, what have you, to create this exclusive right that gave them some intellectual property over that. Trademark was less a sense that you needed to give the property owner an exclusive right for its own self, to incentivize it to make a product, but rather to protect the public and, you know, to keep free riders. So the union sort of case, the idea that somebody would free ride on somebody else's efforts. But, you know, the observation that the lines have become really blurred in the 20th and then the 21st century between commercial and non-commercial content in something like native advertising, or trying to decide, you know, what line something is on, is undeniable. It's very clear that that's true, and yet historically we have made that distinction. If we don't want to make that distinction anymore, I would suggest, you know, humbly suggest that what we're doing is going to be elevating speech, and conducting any sort of activity, conducting a business could be an expressive activity. Baking a cake, running a wedding photography, you know, whatever. And while that may be descriptively true as an experiential matter in your life, that you experience your business as expressive, I'm not sure that's a legal rule that we want to apply to keep, you know, truth in advertising. I mean, the Supreme Court in the Palm Wonderful case, Justice Kennedy seemed to think that was pretty bad to put those big blueberries on the label and not have very much blueberry juice in there. And I'm agreeing with that. I think that was bad.
But I think the question goes to a more foundational intellectual problem here. If a manufacturer of a product says XYZ about his product in an advertisement, that is commercial speech and is subject to the lesser protection. If the manufacturer of the product puts the exact same statements in the pages between hardcovers of a book all of a sudden it gets full First Amendment protection. And I think that's the height of form over substance. And I think it underscores the intellectual bankruptcy of distinguishing commercial speech as a separate category for reduced protection. The lines can't be drawn.
I'm told we have 1 more minute, which means one more quick question, quick answer. Question number 2, you're not going to be able to. Sorry.
Oh, I'm sorry. I guess it's a little bit of a different question. First of all, I appreciate the articulation that was made that there are 2 sides that have interests in a First Amendment analysis, and I think I heard the point being made that, for example, trademark could be taken to be seen as an example that you're looking at the interests of consumers, and that struck me with a certain question. I think there is a law in Germany that penalizes people for denying that the Holocaust took place. And I'm wondering whether that kind of a situation could be accurately described as the government taking a look at the concerns of the other side or the interests of the other side. If that is not an accurate characterization, then the question, is there anything useful that we can learn from how European speech is regulated, or is free speech here just sort of hermetically sealed?
Great question.
Yeah, that's really profound. Who has a quick?
I can talk about this.
They regulate advertising much differently in Europe and a lot more regulation.
And look, I appreciate the question because I do think it reveals something about free speech here and around the world. I mean, in every democracy, freedom of speech and freedom of the press, freedom of religion, are essential. But the precise boundaries of freedom of speech will, and I think appropriately do, differ from country to country. Of course, in Germany, they had Hitler, right? And I don't think they're unjustified in having somewhat lesser tolerance for certain kinds of hateful speech than we allow in our tradition. But one of the places, and I just want to come back to this to close, in which the United States is a real outlier in a way that I think is not justified, is our emphatic rejection of political equality is a value that can ever justify restrictions on political spending. And that is something that has to change, and I hope will when we get our next Supreme Court.
Thank our panel, please, and thank you all.
Great job.